Hi, I'm Ed Jager, Chair of the Subrogation Group at White & Williams. Welcome to Subro Sessions. Today's episode is part 2 of Mindful Mediation, Navigating the Path to Recovery. Matt, Gus, and Lian had so much fun on our first episode, they are back with 3 new mediation hypotheticals. Don't worry if you missed part 1, but make sure to give it a listen when you have a chance.
Welcome to Subro Sessions, Mindful Mediation, Navigating the Path to Recovery. This is part 2 of 17 sessions that we're going to do on mediation. I'm kidding. We're not doing that many, but mediation is a ripe topic for this point and counterpoint type style, not only for its importance because so many subrogation cases are settled that way, but also because of all the different scenarios that can come up. So we did want to start this by doing 2 different sessions on it. Once again, I'm Matt Ferrie, and I'm a partner in the Subrogation Department with White & Williams. And joining me again are...
Gus, Sara, Counsel at White & Williams.
Lian, Skaf, Counsel at White & Williams in the Subrogation Department. And if it was up to Matt, we would be doing 17 sessions, but Gus and I talked him down to 2.
So we have 3 more hypothetical topics today, and I'm going to be presenting the first one. And this is, again, it's a common situation. The mediator and or defense counsel insist on the party decision makers being present at the mediation. This was, certainly probably a more significant issue pre-COVID and the much greater frequency of virtual mediations, but still remains a significant issue with mediations today. So giving our point to this hypothetical is going to be Gus. Go ahead, Gus.
Thank you, Matt, for your graciousness. I will say that I'm taking the pro here because there's nothing like being in the room. And that's even relevant for virtual mediations because obviously there's still a such thing as a virtual presence, and having the client decision maker there, I think holds equal amount of weight as an in-person mediation. There's really no substitute for witnessing the mayhem for oneself. It is the best way to truly understand the posture of the case and the likelihood of settlement. A mediation is a good chance for the client, the decision maker, to get a larger view of the case. A critical part of the case are always, as we know, the characters involved. This is a people business. Personalities of the defense attorneys, the clients, the adversaries, and the mediators all contribute to the dynamic of the case. So a mediation is a great opportunity for a client to better understand all the players involved in one day, or sometimes multiple days, but in one event. Maybe the adversary comes across far more credible than the client thought, which may cause the client to reconsider their position or to reduce the demand. Maybe the mediator addresses some really good points that the client would not have heard the same way with the same effect if he or she was not present. These are all invaluable aspects of being there, be it virtual or in person, just to witness the sausage being made. In most instances, up until the mediation, the client only gets a view of the case from the subro attorney's perspective. Hearing a case from all perspectives can have a greater impact on the client than a status report. The mediator can be far more effective in person. You can all relate, even in our own lives. There are some instances where we have to say something to someone and rather do it in person than over the phone. And there are obvious reasons for that. It is far more personable and impactful to explain one's perspective in person. And mediators understand that. That is why most of them often insist on clients being present at the mediation. And I've had mediators even demand the client's or decision maker's attendance at virtual mediations for the same reason. In fact, some mediators do not even like talking to clients over the phone. They just don't feel like the magic is there and they're going to be able to be as effective. It is better to have the person with authority at the mediation. It increases the chance of reaching a settlement. And again, I think with virtual mediations being the new norm, this position doesn't change. I think it still remains incredibly important. And lastly, having FaceTime with your client is always valuable. There's really no substitute. You can catch lunch, you can catch dinner afterwards. And sometimes that's where relationships really grow.
Thank you, Gus. So, Lian, Gus, with a strong start, what are some compelling reasons why the client decision maker would not be necessary at the mediation?
All right, so I'm taking the opposing view here. We're all adults. At least Matt and I are adults. And with Subro clients, we're all seasoned professionals, So everyone can understand and appreciate all of the issues involved in a case without necessarily having to be in the room to hear them. Now, what are the chances defense counsel is going to raise some novel issue that will blow the socks off your client? Is it possible? Sure. But it's also possible they say something that either sours your client on wanting to settle with them or reinforces their position even more. I know I'm not, breaking any news here by saying that lawyers like to hear themselves talk, but they do. And mediations are great forums for that.
This is a podcast after all.
I know. I recognize the irony. However, from the longest war stories to condescending soliloquies, joint sessions at the beginning of mediations are often when attorneys drone on the most. So if mediators insist on openings, I don't think there's much we can do about, grinning through it yourself. But making your client sit through an opening mediation session where opposing counsel grandstands for an hour, may just put you behind the 8 ball right off the bat. It may also be considered cruel and unusual punishment. Don't put your client through it. If it's a strong case, and even more so if the mediation is compulsory, not having your client attend might signal to your opposition that you're ready for trial if they don't make a deal. To a certain extent, litigation is a game of chess. You never want to go to mediation without the good faith intention of settling. But if defense counsel is not coming in good faith, or you sense they're not going to be putting up real money, don't let them have the satisfaction of making your client waste their time. Show them that you're just as resolute in your position. Again, you want to go in good faith, but this is especially if you're in a jurisdiction where they make you go to mediation and defense counsel is coming kicking and screaming anyway. Don't make your client sit through it. Generally speaking, I think insisting on anything is a bad initial tone to set. Mediation is about compromise. So starting off with a take it or leave it rule, I think makes me skeptical of the ultimate success we might have. If it's the mediator who is insisting and he or she is not a former judge, I'm also a little skeptical they know their purpose. They're not there to enforce, rigid rules, but to be flexible and move with the will of the parties to do whatever they got to do to make this thing, get settled. Matt mentioned earlier, and I think Gus talked on too, about, doing a lot of virtual mediations now in the COVID area. I don't like doing things virtually, but mediations are one of the aspects that I do think, has some benefit doing over things like Zoom. So if you are doing a mediation over Zoom and your client needs to be there, why not negotiate to have them come in and out as necessary? They don't need to sit there all day. They don't need to necessarily be in on different parts of it, but they do, just have them come when the decision time comes around. So, if a mediation in person means flying across the country or driving several hours, whoever insisted on the parties being present better be serious about getting a settlement done.
Well, nice comeback by Lian. I have to say, I think that Gus gets a competitive but clear points decision on this one. I think that you do want to have your client decision maker there, if possible, at an in-person mediation. Obviously, virtual mediations make that a little bit easier. And I do agree with Lian that client attendance at a virtual mediation can be done with them popping in and out. It's not necessary for them to be there the entire time. So moving on to our second hypothetical, and that is by Lian.
Okay, so in our first session, we talked about, the pros and cons of sharing a mediation memorandum with your adversary. So now the hypothetical shifts a little bit where we're talking about when a mediator proposes that all parties share their liability expert reports, which hopefully everyone has, with one another prior to a mediation. So first up, Matt.
Thank you, Lian. I'm generally going to go with the pro position for this one. As subrogation attorneys, we are generally looking for ways to settle cases sooner rather than later. So if I know that producing an expert report will substantially increase the chance of getting it done, and there are occasions when you are told exactly that by defense counsel, I'm going to strongly consider providing an expert report. Parties and carriers are generally predisposed to believe, by parties I mean adverse, well, us as well, but certainly adverse parties, are generally predisposed to believe their insureds and their experts over the ones on the other side. To get an adverse adjuster or a defense attorney to start thinking there is a good chance that a jury will believe our expert more than their expert it may be necessary to provide a comprehensive expert report in the early stages of the litigation and ahead of the mediation. A very small percentage of subrogation cases go to trial. So the extent that hiding the ball regarding your case was ever a viable strategy is significantly less viable now. If you have a strong theory, a strong expert, thorough investigation, etc., then it's usually best to lay your cards on the table. Yes, some facts may change down the road, but a supplemental or rebuttal report can often effectively address any such developments. In many instances, the pros of producing a report early on outweigh the cons. Of course, there will be cases where not providing an expert report prior to the mediation is the best play, and you have to take it on a case-by-case basis.
Very interesting. Gus, I don't know how you're going to counter that one, so I got my popcorn ready.
Matt makes a good point that this should be evaluated on a case-by-case basis, but I'm more likely to provide mediation memos to the adverse party than a liability expert report or a damages expert report for that matter. While I understand that laying your cards on the table philosophy of providing an expert report for the mediation, and it's sometimes appropriate, there are also occasions where it could do more harm than good. In most of our cases, the defendant was given the same opportunity to inspect the law site and examine the same evidence. Despite this, if you're in litigation, defense counsel's expert presumably reached different conclusions than your expert. And now you're in a battle of the experts case, which we often find ourselves in. Adverse adjusters often request our expert report pre-suit when we are trying to settle the case. I rarely have my experts even prepare a report until it is time to share the report pursuant to the case scheduling order in litigation, where by that time there's a lot of discovery out and you can have a full and complete report rather than doing it through a piecemeal process, which in my experience can be hurtful to the case. In my view, if our expert inspected the same scene and examined the same evidence, then a conversation with the adverse carrier regarding our respective experts' findings should be sufficient to determine if the case should settle. We all saw the same things. Here's my expert's spin on it. How much are you going to offer? That's the way it should work. If our experts substantially agree, then the case settles. If not, then it is my experience that the adverse carrier is not seeking our expert report in a good faith effort to determine if their expert is incorrect. Love to see that, rarely happens. Rather, they have no intention of changing their liability position, and they're just trying to get a head start on how they can defend against our expert's opinion in litigation and trial, and even at the mediation. The concept is similar for mediation, just as it is in litigation. Our experts presumably already developed a good faith liability opinion based on the physical evidence, but his or her opinion is typically not truly complete until documents and testimony have been obtained from the defendant in litigation. If the mediation occurs before the end of fact discovery, then you're providing an incomplete expert report, which could be hurtful. The adverse party may think that aspects of our expert's report can be devalued or contradicted based on information we do not yet have, but will be obtained through further discovery from the defendant. Sometimes that's why we're in litigation, is to fully develop the facts of the case. Those aspects of the report may be minor and or can be modified through a later supplemental report. However, it is harder to change a perception than to create one.
Socrates.
That is philosophy that we should all learn from.
I'm writing this down.
I'll give you a second if you need it. I generally want the adverse party to see my expert's opinion in its best light from the first impression, rather than try to change an unfavorable first impression, like all of Matt's first impressions.
My wife would agree.
Additionally, yes, there's more. Sometimes the expert's opinion, while inherently bolstered by the expert's education, training, and experience, is based on obvious observations and clear and understandable code provisions. In those situations, it usually makes little sense to engage in the costs and potential complications of a formal expert report when the expert opinion can be easily articulated and supported by the attorney's mediation memorandum, which I often try to do. And as you know from part one, I'm a proponent of sharing the memo, and I try to articulate our expert's theory.
All right. Well, I'm going to take this opportunity to play judge and take the liberty of asking a follow-up question. Matt, so what if you get stuck with a report before you get assigned the case, or an expert writes you a report you don't like? Are you still going to produce it at a mediation?
Absolutely not.
That's what I thought. All right.
But I would say this. I mean, if you, in giving me this hypothetical, I'm assuming that the report can be improved, right? Are you talking about it's just a terrible case and that's what it is? Because it's a terrible case and that's what it is. You should be reevaluating whether it's even in suit to begin with. But if it's a report that could have used some more work, could have better articulated what our theory is, then chances are what I would do is have our expert draft a report that is more consistent with our facts and shows our case in a better light, and I would provide that.
In case this is being recorded, I just want to clear the record. I was taking that position for the purposes of our discussion. I often share expert reports with mediation memorandums. I include it as an exhibit, and I always say it's a preliminary report for mediation purposes only, especially if my liability theory is good and I'm confident in my expert's opinion. I know I articulated my points so well and so expertly that you thought that was my genuine position. But
no, interestingly enough, Gus and I were on the opposite sides of this particular hypothetical, and we decided to switch for the fun of it to give the opposite perspective. So nice work, Gus, in terms of articulating what I told you to say.
You're a great loser. So we're moving on to hypothetical number 3. I'm going to be presenting this one, and Lian will be providing the pro, and Matt will provide the counterpoint. So in this hypothetical, defense counsel wants to use a mediator who has a reputation of being pro-defense, or a mediator who has a quote-unquote conduit of information style, rather than offering his or her opinion on the merits of the case. Lian, how do you respond?
Okay, well, first, a deal is a deal. Doesn't matter how you get there. If they feel like they have a better shot at reaching a settlement with a former defense counsel who's a mediator, sure. No matter what the mediator did in his or her former life, now their goal is to settle cases, and they will do that by whatever means necessary. So pro-defense or not, if we're not happy with the offers being made, we're not going to settle. There's really no downside, in my opinion. So agreeing to use your adversary's choice of mediator is not just a show of goodwill, but I may even try to argue that, it's my first quote unquote move in the mediation is to say, hey, we agreed to, your person here. Now you make the first offer. A mediator that's defense oriented can also help show your client, and maybe even you, some of the defenses you either didn't consider or are not weighing heavily enough. They may be able to also specifically show defense counsel why his or her arguments are not as strong as you would hope. That being said, not all mediators come from the same backgrounds. So, they may not be as familiar with the insurance industry or property damage versus personal injury or certain types of tort cases. Thus, while a mediator who is a former subrogator may be an excellent advocate for your argument, that's not always the case. So oftentimes you need a mediator just to be the go-between between the parties, or as we said, conduit of information. So most likely, everyone knows everyone's arguments ad nauseum at this point when we're in the mediation here. So the mediator really just has to get us to a settlement. The number one skill I look for in a mediator is the ability to will parties to compromise. So while that can sometimes involve arguing one or both positions being presented, it can also be displayed with only a general understanding of the issues. The power of persuasiveness is often rooted in understatement. You like that, Gus?
Mwah, beautiful.
Hang on, I'm writing that down too. Gus, he stole your philosophy book. All right, as I mentioned in our previous segment, my general philosophy is that any mediation is hardly ever a waste of time. I want defense counsel and the adverse carrier thinking about resolution instead of thinking about further litigation. So I'm not obsessed with using the quote unquote perfect plaintiff's mediator every time I mediate. It's typically not going to bother me if the mediator is considered pro-defense, especially if that is what is necessary to get the adverse party to attend the mediation. If your case truly has some merit, that will come out through how you present the case through your mediation statement and or at the mediation itself, regardless of any pro-defense tendencies of the mediator. That being said, I do, of course, consult with my colleagues about any mediator that's proposed in my cases. And if the feedback I receive is that a mediator is so pro-defense that he or she should never be used, I'm going to tell defense counsel we need to use someone else. Of greater concern to me than the mediator's potential pro-defense philosophy is the mediator's style. Wherever possible, I try not to use mediators that only view themselves, as we've discussed, conduits of information at the mediation, and do not offer their own opinions on the merits of the case or try to work on a party they feel is being unreasonable. I feel a conduit of information style mediator to generally be unproductive. All right. An email is a conduit of information. An envelope is a conduit of information. All right? A carrier pigeon is a conduit of information. All right. I can send messages.
A podcast
is a conduit of information. I mean, I can do all this myself. I don't need a mediator, right? We select a mediator and compensate them well because they are an experienced and well-respected voice in litigation whose opinion will, or at least should, carry weight, and whose mediation style will get things done. If I'm mediating a case, it typically means that I think the adverse party has thus far been unreasonable in how they have valued the case. I want a mediator who will tell them that, if that is the mediator's opinion. Similarly, despite our best efforts, we can sometimes view our cases through plaintiff's colored glasses, and it's beneficial for us to hear from the mediator that we are overvaluing our case and why. Of course, any mediator can potentially tell you your case is not as good as you think, whether they believe it or not, just to try and get the case settled. But part of our value as subrogation attorneys is our ability to determine when a mediator is making legitimate points or just playing the game.
Great points, both of you. Please don't make me decide. That was really close. As a wrap up here, again, as we stated at the end of part 1, every mediation is different. And it helps to have a fluid understanding of the different strategies available and when to use them. There are so many dynamics to consider that one approach cannot be used for every mediation. There is no cookie cutter format to mediations, but hopefully some of these points will come in handy for your next mediation.
I like to add, mediations are a good time to think outside the box. Be creative about ways to move settlement in the right direction throughout the day and get the deal across the finish line. Unlike trials, arbitrations, and even some motion hearings, to a certain extent, the pressure is off a little bit. Sure, everyone wants to settle the case, but if you don't, the case continues on, so you might as well swing for the fences.
While some litigation is unavoidably contentious, my feeling is that adversarial generally does not have to mean antagonistic, particularly in property damage cases. A mediation is a great opportunity to show the adverse decision maker, as well as any defense attorney, that you and your client are reasonable people who simply have a different but plausible opinion on the merits of the case. Even if the case does not settle that day, that perception can tilt in your favor how difficult the adverse party wishes to be going forward, as well as their perception of what a jury may decide in the case. So Lian and Gus, always great talking to you guys about subrogation. Audience, we hope that you enjoyed the first 2 Subro sessions we have done together. This is the conclusion of part 2 regarding mindful mediation. No matter what, there is one thing that we can promise you, and that is that our next session is not going to be about mediation. So thank you very much for joining us.
Thanks for listening to Subro Sessions. On our next episode, Melissa Kenny will discuss the adjuster's role in the subrogation investigation. In the meantime, if you have any questions or suggestions for future topics, email us at www.info@whiteandwilliams.com.